doing your best to make sure that nobody else is already using, using your brand or using your prospective trademark in commerce on, on related goods and services. So, really fundamentally, it's about, make sure you don't put all your money and, you put all this money and effort into building the brand and the company name only to get out in the marketplace and realize somebody's already doing that. So you have to go back and pick another name. So, a good starting point for it is even if you go to the U.S. Patent and Trademark Office website, it's called TESS, TESS, and I always forget what the whole acronym stands for, but of course the T is trademark. But if you just Google USPTO TESS, it'll take you to their search interface. And while it's not the best search interface, at least typing into the search box, the prospective name for your company, just seeing what hits you get. And if anything, you shouldn't do this yourself to to become comfortable that there's nobody else using your trademark, but you can save some cost if you go in and just start searching. And it's more if you find others using the trademark that you want to use in the same space, you just know to pick out another one, and you don't generally even need to call your counsel. But again, the message here is just make sure no one's using the mark, and then from there, you also do want to think about obtaining federal trademark registration over your brand, because then what that will do is it will give you enhanced protections on preventing other people from coming in and using a confusingly similar trademark. And even in that context, it was an example that was getting somewhat dated, but thanks to Amazon Prime, it's kind of right back front and center, because many of us remember the original Coming to America movie where there's the restaurant McDowell's, which is a complete knockoff of McDonald's. And, not to spoil it for anybody, but McDowell's does make an appearance in Coming to America 2 that came out within the last month or so. But, that's a great example of trademark infringement and what not to do.
And Joe, the other thing too, I guess, with trademark is that I usually point out is regarding, like, it can't be exactly describing the item. You have to, because we've gotten blocked before on a trademarks, saying that it was basically the Webster's description of what we were doing, for instance. So can you mention that?
Yeah, certainly. There's what we call kind of a spectrum of different types of trademarks, and only certain types can get protected. Where on the the far, I guess I'll call it the far left end here, even though it's mirror for you, so it might look right. The far left end are the arbitrary or fanciful trademarks. Examples of those would be Kodak for film, or Nike shoes, where it's either in the case of Kodak, a completely made up word, or in the case of Nike, it's a word from a foreign language that has really no relation to your product. So those arbitrary and fanciful trademarks are, they're typically, they give you the most protection, and they're also the easiest to get through the patent office, because they are, they're not in any way describing the product. When we take a step over on the spectrum, we then get to what are called just suggestive trademarks, where they suggest an attribute of the product, but they're not directly describing the product. So if the mark is suggestive, you can still obtain protection there. So, one example would be something called Teaminade, where it's just sort of describing attributes for an iced tea, but not directly describing it. From there, you get into merely descriptive trademarks, and that's where it's a trademark it's directly describing the attributes of the product, and it doesn't require any real thought to figure out what the product is. With descriptive trademarks, an example would be, they're typically harder to come up with examples of descriptive because they almost always are also generic. But
I can help you, Joe.
Yeah, go ahead.
Excuse me for interrupting. So not in the US, but we have a product, it's called a vehicle restraint, and it's intended to hold the truck at the loading dock. And we call that a dock lock. DOKLOK. Now, in the US, the spelling was sufficient. Was sufficient for it not to be descriptive. But in Europe, we did give the descriptiveness rejection because it locks the truck to the dock. So they said that was descriptive or suggestive at least.
Oh, thank you. Thank you. There we go. And then on the far end of the spectrum and then to come back to with descriptive trademarks, even if they're rejected initially by the trademark office, you can still obtain registration if you're able to demonstrate what's called secondary meaning in the mark, meaning that the primary significance of the term is a designator of source in the mind of the relevant consumers, as opposed to just describing the product. And so typically through careful advertising where you're using the trademark as an adjective to describe the product and not a noun, you can demonstrate to the trademark office this is obtaining secondary meaning. And then
and excuse me again, Joe, just quickly to Joe's point, in Europe, ultimately we do have a registration for DocLock because over 20 years of successful advertising and demonstrating to the trademark office that we had acquired secondary meaning, we were able to obtain a registration.
And then the final category of trademarks are what are called generic marks, and that's where it's just the common noun for the product itself. So you couldn't register truck as the trademark for a truck. Or another very common example is aspirin, where, interestingly, aspirin was originally a trademark by Bayer AG for the use of salicylic acid in connection with like an analgesic product or a pain reliever. The problem is that aspirin became so popular, the relevant consuming public started using it as the noun for the product. And Bayer did not do a proper job of what's called policing the mark. And by the time they tried to, it was too late. Another example of a mark that almost went generic is Xerox, where, particularly, if you were around in business in the 80s and into the early 90s, the prevalence of the photocopier that everybody called just the Xerox or the Xerox machine, and Xerox actually had to go on an affirmative ad campaign imploring people to stop calling it just a Xerox and that it's a Xerox branded photocopier, but they were able to preserve their trademark protection.
So then maybe Google will go off since we Google everything.
It's interesting. It'll be interesting to see what. Yeah. I mean, ironically that, to some degree it's good news when you're running the risk of a mark going generic because it's demonstrating the, massive market share that you have. But, at some point, they may have to step in and do some defensive advertising.
Or just eliminate all other search engines and everything is a Google. And so then it can be generic and it's fine.
Right.
Oh, and by the way, everyone, feel free to put any questions in the chat box or, raise your hand and whatnot, as we'll be jumping to new topics as well. So if there's anything else, questions on trademarks, feel free to jump in now. Kyle, and if you have anything else you want to add.
Just that as an engineering staff, you have to be careful with respect to accidentally calling things. I actually ended up in a situation where we had to kind of backfill the brand name topic of a material when I was in a prior job because we would refer to it by internal slang. And, it caused a real problem with our legal folks. So when it comes to from an engineering perspective, trademark and the terminology used in the market can actually be challenging. You need
Okay. So next topic I wanted to jump to is patents. Obviously, that's a big realm for many of the technologies that we're dealing with. Kyle, maybe if you want to touch upon that, but everyone really can jump in. Or am I doing this wrong? Or was Joe going to talk about that? Whoever would like to start talking about the importance of patents and kind of the key features you need to worry about. And someone just commented, Kyle, that your audio is somewhat going in and out.
Yeah, I'm sorry. I've had this issue. Better?
For now, yeah.
So ultimately, what I from the technical folks in the room, or in the virtual room, what I'd recommend that they think about a patent is it's not a technical document. That's something we have to train a lot of researchers on. It's a legal document. It has legal ramifications, and so something not obvious to you, or something obvious to you may not be obvious to a practitioner in the art. And what is patentable isn't necessarily well can be confusing to the individual researcher. So it's something that I would strongly recommend you deal with legal counsel on a regular basis and make sure you understand it early, because it is a race to the patent office, and your legal counsel is going to be the person to really help you do that and get those exclusionary rights. There are also strategies around publicizing things on purpose and making sure access to that, and we can get into that if the audience is. But ultimately, from my perspective, you need to be remembering that it's not a technical document, it's a legal document. My audio better?
Still a little bit fuzzy. Any patent attorneys want to jump in as well?
I will.
Yo, go ahead.
Oh, very good. So, well, I think taking a step back especially with a startup company, in terms of your strategy, I'll kind of bake in trade secrets into this a little bit just to explain the difference. Where when you're a new company that has developed a technology, if there are kind of two fundamental ways to protect that technology, either through one, filing a patent application, or the opposite side of that same coin is relying upon trade secret protection to protect the innovation. And really one of the key factors in making that decision is that if your product can be reverse engineered by competitors, then you really have to seriously consider filing a patent application on it, because trade secret protection only exists when the secrecy of the information gives you a competitive advantage. So if your competitors can reverse engineer your product and figure out what you're doing, then you have to rely upon a patent in order to exclude others from practicing that technology. So I think, in a little bit we can get into like how you obtain a patent, but that's really the kind of the starting point for the decision is, do we file a patent application or not? And in part, I'll step back a little bit for early stage companies about why that matters is, largely when you develop a startup company, typically your goal is to exit or be acquired by a larger company and, recover a lot, hopefully more than what you've invested in the R&D and everything else. And when larger companies are looking to do acquisitions, very commonly, the first thing they're going to look for are revenues and customers. So really, when we look at technology life cycles, the big companies are going to be, just by their nature, more risk averse than the startup companies. So when there's a new emerging technology, the big companies will sit back and wait a little bit and watch the smaller companies battle it out in the marketplace to see who develops the winning technology. The winning technology, the criteria for winning is customers and revenue. So whichever product acquires the customers and revenue, that's going to be most interesting out of the gates to the big companies. So then the big companies will very commonly acquire those companies first. But then when the big company makes the decision to go in and do that acquisition, they are also going to want to, acquire the IP in that space so that they can push everybody else out of the technology space. So as a startup company, hopefully, number one, you're already the company with the customers and revenue. And then on top of that you were the first to file a patent application on that technology. But unfortunately, it doesn't always work that way, where usually it's somebody else with the customers and revenue that gets acquired, and it's another company that has the core patents on the technology. And that's where your patent portfolio can be all the more important as a startup venture, because even though you're not that interesting because you haven't acquired the customers and revenue, because you have the patents covering the core technology, you're still very interesting to the big players for acquisition. So I kind of see Kyle nodding to that. So, from the business perspective, he can maybe add some further color to that.
I sit on Rockwell's venture investment council, and that's a sustainability of the advantage is critical. And obviously, the patent or trade secret is absolutely critical. And it makes that part of the conversation so much easier. If that's not there, it becomes a very challenging conversation with respect to even the sustainability. If we're just buying that customer book, we're large, we can go do that. That's not a question for us. So the sustainability of the advantage, that exclusionary right, is oftentimes just huge.
Yeah, and I would add to that relative to startups. I think it's important to have a sensitivity, behind the patenting process, because as a startup, you're completely outward facing. Obviously, you've got technology or whatever, and you've developed it. But as you're trying to grow, you're outward facing because you're trying to attract investment, you're trying to attract customers, maybe even you're trying to attract partners. And it's important to understand in that regard that if you're making the decision based on detectability of infringement or other factors that you want to go the patent route versus the trademark route, you have to be sensitive to the fact that once a invention, a patented invention or a patentable invention is disclosed into the public domain, as a general proposition, that eliminates your ability to get a patent. Now, in the United States, we have a little bit of a different system. Once you make a disclosure in the United States, the inventor has a year, basically, to file their patent application. The United States, however, is unique in this regard. So in most of the rest of the world, once your invention's been disclosed, you can't patent it. So it's something to think about for a startup. And to Kyle's point about the importance of that IP for sustainability, if your exit might be to a big multinational company, they're going to be interested in patents everywhere. And with that awareness, should be sensitive to the fact that even though you might have this time in the US after you disclose it to file your patent application, that's not the case in the rest of the world. And so being sensitive to that and having appropriate structure in place, whether it's NDAs, although you're not going to get investors to sign an NDA, or having appropriate protocols in place within your organization to make sure that you're only disclosing things that you mean to disclose, and that you don't have incidental or accidental or unintentional disclosure, and limit your patent rights.
Yeah, I think this is the biggest takeaway of patents when we teach about that at the Research Foundation, is just talk to someone before you start telling the world about it. I mean, even we've seen, sometimes inventors try to post things about their invention on LinkedIn. That's public too, so you may not realize that everything you're doing is public. So just always talk to someone at the Research Foundation or a patent attorney. We can introduce you to these patent attorneys that we know, and be careful. We're going through this right now with some papers that came out, and what countries can we now file in since the papers were already published. So it's probably the biggest takeaway here. Does anyone have any questions about patents? I know there's so much detail in patents. This is just a brief overview, but just some considerations as you are, dealing with your own startup. We'll want to give you those key takeaways, but we can always follow up afterward. Anything else, or should we move on?
Yeah, I was going to comment. We talked about obtaining patents, but I think we should also talk about what do you do once you have a patent. So in the enforcement side. And it's important rather to understand, I think, the nature of the patent right. So those of the patent attorneys among us, typically there's all kinds of ways to refer to this as a negative right or an exclusionary right. But Kyle used that terminology about an exclusionary right. And it's important to understand that that's what a patent gives you. For the invention that you patent, you have the ability to prevent or exclude others from using your invention, okay? So it's important, and that's the only right. It's a set of rights. You can prevent others from making, using, selling, offering for sale, and importing your invention. but it's all about your ability to prevent other people from doing something. That's why we refer to it as an exclusionary right or an exclusive right. What it doesn't do necessarily is give you the right to do anything, okay? So even if you have a patent on your technology, you only have the ability to exclude others. And it's possible that even if you have a patent on something, that you still may not be able to practice your invention because someone else has what we would refer to as a dominating patent. So let me give you an example to clarify that, because I don't want to freak everybody out. But let's say that, let's go back, 80 years, and someone has invented television, okay? And there's an entrepreneur who gets tired of walking across the room to change the channel and turn it on and off. So he invents a television that is capable of interacting with the remote control. So now he can turn it on and off from his chair. And he gets a patent on that combination of the television and the remote control, okay? The issue there is now he can prevent anyone from making television and remote control combinations, okay? What he can't do without obtaining some other rights is sell the product himself, because, and I should have started with the preface that there's already a patent on televisions. So he's combined something with the television. Now he's got a package of a television and a remote control, but there are patents on the television itself. So even though he has a patent on that combination, that doesn't mean he has the positive right to sell that product. He can exclude others from selling that combination. So it's an important distinction, and you know, a recognition of the nature of the patent rights. Just because you have a patent doesn't mean you can practice the invention.
And that term is called freedom to operate, right, Matthew? So when we work with inventors or companies, my office, we aren't attorneys, so we don't perform a true freedom to operate. And can you guys give us a ballpark? And there's another comment as well, but like, this is something a startup should do in general, but it can be costly. What would you say a ballpark is for having an attorney conduct and help you with a freedom to operate search?
So it's, you know, unfortunately real hard to give numbers on that, aside from saying it's
tens of thousands.
It's pretty expensive. I'd say at least tens of thousands. And it really largely depends on what technology space you're in. My experience is that most, I shouldn't say most, it's common for startups not to do this simply because it is cost prohibitive. What startups will typically do is, you know, when we're looking at if there's resources to do a patentability search on the technology to help assess whether the startup could get a patent or not, we will look at the patents that turn up in the patentability search to help sort of, you know, give higher level guidance on that. And if there's not, you know, and a lot of times we don't even do the patentability search before filing. In that case, we just sort of see what patents the patent office has come up with. And we just sort of recognize that you're flying blind. And part of, with freedom to operate, you're always flying a little bit blind anyway, because at the earliest, patents are not published until 18 months after they're filed. So you're never gonna have true confidence in freedom to operate anyway. So you just do the best you can. And, you know, sophisticated investors, you know, everybody will understand this is it's a known risk as you're moving forward.
Right. And you guys can do your own searching for free online. We use Google Patents all the time. You just type in patent, Google Patents, and they have a really great, obviously, search engine. You can also use the search engine at the USPTO. So you can do your own, you know, preliminary freedom to operate, make sure nothing hugely obvious pops up. And then there's a question about budgeting for patents. And in our office, you know, we've looked into this and had a good sense of it. For instance, one US only patent can range depending on how quickly you get through the patent office and how much arguing there is. But I would say, you know, there's been a range from 18,000 to like 40 something thousand. So on general, I tell people 20 to 25,000 just to get one, you know, US patent. Now keep in mind, if you need to go into Europe, China, other countries, then that's going to, you know, be another whole chunk of near probably that same amount for each country, maybe a little less, but maybe Joe, is that, you think, appropriate.
I think so. Yeah. I mean, like budgeting 25,000 for the full, to get the patent to hopefully issuance, where, just preparing the patent application and filing in the first instance can be done for, less than 25, but yet that's a safe number to start with. And, and really I would say that as the complexity of the technology increases, so does the cost. So, typically your software-based applications or your biotech or chemical tend to run more expensive than, a purely mechanical, even though it's pretty rare that we come across purely mechanical anymore. Almost everything is electromechanical or has a software component to it. But, it's just the more complicated the technology, the more the patent application will typically cost.
Right. And then the filing, I should say, like the first utility filing, let's just say it's in the ballpark of, 10 to 15,000 and with a combination of attorney fees and the US, patent office fees. And then the arguing can take, using your attorney, several $1,000s per argument back and forth. So that's where I kind of come up with, let's say 15,000 plus 10,000 if you go back and forth a few times. And that's pretty smoothly if you only go back and forth, 3 times. But there are items that we've done that have hit, 40 something thousand.
And I think, I'm sorry, go ahead.
Go ahead, Matthew.
I was just saying, I think for the startups, these numbers are super important because, typically if you're licensing out of the university, typically you have cost obligations for those patent costs. So, the more education you can give yourself, the more you can engage in the process, and to the extent that you're capable of doing not necessarily the legal work, but despite the fact that Kyle is right that a patent's a legal document, reviewing patents is technical, right? And there's certainly a technical aspect to it. So, you can help yourself out and keep those costs, not only keep those costs down by being actively involved in the process, but hopefully also, improve the quality of the results because, the best patent attorneys, within reason, a patent attorney, if you give them a disclosure, they can patent something. Okay, typically, if the disclosure is good enough. But the reality is that, having a patent is important, to Kyle's point about sustainability, but a valuable patent is much more important than just having a patent, or certainly can be. And, your patent attorney who you're working with, unless you're giving him the information about what's important, either what's important to you, or most relevantly, what's important to your customers. Because to the extent you can patent the features of your technology that customers care about, that's where the most value is. Because if you can prevent other people from making, using, or selling the things that customers want to pay you for, those are the most powerful patents. And those are when Kyle and his team does the analysis of your company and assesses the scope of the patents, if they're protecting what the market cares about, those are going to be considered more valuable and they'll pay you a bigger premium to acquire the company.
So can you hear me on the phone? Is this better?
Yeah.
Oh, beautiful. Sorry about that, guys. Freedom to operate, I just can't reiterate that enough, where it is an idiosyncrasy as people come out of universities, and I don't know the legalities of it, but there's different rules that cover somebody that's doing research in a university environment versus like even what I can do in an industrial research environment. And so sometimes those rules can't, that's one of the first, when I know that a startup's coming out of a university, freedom to operate is one of the first questions I'm asking, because that's not necessarily something that in a pure academic sense that people worry about. The confirmatory experimentation except is encouraged in those types of environments. And so it can be an idiosyncrasy that is important, and I've seen it catch up. In particular, the example I got involved with was friction stir welding, where the base patent for friction stir welding was held by the Welding Institute. I believe it was the Welding Institute in the UK. And there were all of these improvements on that base patent, but all of it was choked by this one fundamental, really great piece of work, and it was a great patent for them. But it created the adoption of that technology was significantly delayed as a result of kind of everything going through that one patent owner, and good for them, right? Absolutely great business practice. But it is an idiosyncrasy. I would encourage all of you to understand and realize that, like, I think an organization that's dealt with university startups is going to ask about, maybe they don't use the term freedom to operate, but they're going to start asking questions about, like, have you done any prior art searches? Do you understand? Can you actually do this commercially? Is what they're going to ask in some form.
And on the same note of patents, and Joe, you said in the beginning, you have to decide trade secret or patent. I think that also ties to, can you detect infringement? So if you can't tell that someone's using your technique or your method or your device, then the patent is pretty much useless in that sense. So can you guys touch upon, infringement? How would you detect infringement? And obviously the patent office doesn't detect it for you, so it's really up to you. And I'd love to hear more about that.
So certainly, detecting detecting infringement rather, just through getting your hands on the product and doing the reverse engineering. I mean, then there are companies that will do this, like in the semiconductor space and other in other technology arenas. There are companies that will they'll do the analysis for you, but it can get expensive. But I think to your point, Jessica, is that when you're writing the patent application and writing the claims, typically writing the claims with an eye towards, will we be able to detect the infringement here or not? Because just recognizing if you're going to have to spend $50,000, $100,000 to figure out if someone's infringing or not, on the front end, it's not going to be a very valuable patent. And then that would be to that end, that's where if that's going to be a problem, then you start thinking seriously about trade secrets, because if it's that costly and expensive for you to figure out if someone is infringing, it's also that costly and expensive for somebody to figure out what it is that you're doing. So recognizing that if through the reverse engineering somebody can figure it out, it will eliminate some of your trade secret protection. But again, on this example, if it's that difficult to reverse engineer, there's probably a lot of know-how that will go into the manufacturing process. So then even if through reverse engineering you're able to identify some of the components or features, but again, still really difficult to figure out how it was manufactured, you might still be better off just relying on your trade secret protection. And then I guess one point I'll raise, but just stop me if this starts getting too off track. But I think also important to recognize that getting your patent, as Matthew was alluding to, getting your patent is just the first step. That the Patent and Trademark Office does not actually enforce your patent. So it's actually up to the patent owner to enforce your patents in the marketplace. And so, that can be a very expensive process. But over the last 15 years, the marketplace has evolved to where there are other outlets to assist smaller entities in enforcing their patents, where right now it's becoming more prevalent. It's probably not, I won't call it common, but what's becoming more prevalent is when companies have patents that are being widely infringed and have significant economic damages through that infringement. You can now obtain what we call third-party funding to assist in the licensing and litigation campaign. Because if you go back 30 years ago, if you were, as a small entity, you get your patent and you go to the big entities to try and obtain a license, it's very difficult to do that. Where certainly big companies, I know they're always very interested. They're interested in looking at new technologies, but what you will sometimes find is they call it the NIH mindset, the not invented here, So if a large, and I say that because if a larger company has already spent the R&D dollars to develop the technology in-house, the business case isn't as compelling to take a license from a startup that sort of did the same thing. So I don't want to paint the big companies in any type of sinister light, but yet if they've already done the internal development to release it, they don't really see the value in it. And particularly 30 years ago or more, the larger companies weren't too concerned about small entities trying to enforce their patents. But now, the playing field is getting more equalized. So I think just to not feel a sense of defeat, because ironically, as a startup, one of the best things that can happen is seeing widespread adoption of your technology in the marketplace, because that signals that you were onto it, that you filed a patent application on the direction the market was headed. And to realize that even though you don't have the resources to enforce the patents, under the right circumstances, you can now get third-party funding to step in. And understand it's not free money, but yet it's a resource to help you enforce.
So jumping in really quickly on trade on secrets. One of the questions we're going to ask, if you're going to claim a secret, we really need to know, and I'm definitely not an expert on the requirements for it, but there are requirements for how you protect those things. So if you've disclosed them, if you haven't taken proper steps, then you can't necessarily claim the types of protections that maybe you think you can claim. So there have been instances where people are claiming trade secrets when we did our basic due diligence, we discovered they weren't protecting the information to any great degree at all. And we started to question whether we could even claim those rights. I'm not an expert on what those requirements are, but I know what the requirements are at Rockwell when we claim a trade secret. But there are some minimum standards that have to be dealt with.
And I wanted to point out too, I don't know if we said this, that you can only go after people for infringing in the country where you have the patent. So if you have only a US patent, someone is free to make, use, and sell in China or in Europe. So you're only protected in the country where you have that patent. And that's the only place you can stop them. So they can't import, or export from China into the US. You could stop that, but they can just do it out there without any,
Yeah, and I think that's really important to point out. And and frankly, sort of one of the great difficulties of making decisions about filing patents and foreign filing patents, because typically you're having to make these decisions before you have the adequate information that you'd want to be able to base the decision on. So I said earlier, my opinion that I hope my colleagues would agree with, that valuable patents protect what's relevant to customers. Why do they want to buy your product? That's what you want to protect with your patent. But the problem is, as I said before, if you want to protect your foreign patent rights, you have to file your patent application before you've even shown it to anybody, before you've made a public disclosure. The problem is you have to make those decisions about where to file before you have that information, before you have put it in the marketplace and let customers vote with their dollars about what they care about. That's certainly true when you first file your patent application. Fortunately, by the time you're making foreign filing decisions, you typically have started to get some of that information. And indeed, there's a structure in place based on the international treaty that helps that even a little more. So once you've filed your first application in the US, for example, when it's time to go and file it in foreign countries, you could go to 10 foreign countries and file it in each of those. But there's also a vehicle referred to as a patent PCT, or Patent Cooperation Treaty application, which basically allows you to file one patent application, foreign file one patent application that will eventually be distributed to the countries that you ask for it to be distributed to. A potential benefit of the PCT, besides saving the filing expense of filing in all 10 of those countries right up front, is your patent application also spends some time in the PCT. That additional time might be a downside if you're in a hurry to get the patent. However, that time may have a benefit as well, because the time that the application spends in the PCT, you can be out making sales, for example, in those foreign markets, or talking to people in those foreign markets and trying to understand whether those markets value the technology you're going to be able to patent. And that may help inform your ultimate decision whether to pursue the patent in that individual country.
We also have a question kind of regarding, can folks, so there was a news article of an investor speaking to a university, and then the investor took the idea and patented it on their own. Does this happen a lot? And, obviously that's why we always try to have confidentiality agreements in place before speaking to a company. Investors don't often sign them. So usually you want to have your patent filed if you are starting to talk to investors. So it sounds like this was a bad case. I don't know how often this happens, but technically it hopefully shouldn't, but can you guys chime in?
So from an industry perspective, we will have initial conversations with a startup not under NDA, and we purposely start the conversation not under NDA, because we're like, what is the publicly available information? Because as a courtesy to the startup, we recognize that just signing an NDA, just having it legally reviewed, can be costly. And so with publicly information, if I can either decide I'm interested or walk away, that's just a courtesy to that individual, to that group. But we say a bunch of times, don't tell us anything private, anything confidential. We don't want it until we get everything under protection, because that's just the best practice. As far as inventorship, there's lawyers, on the panel that can speak to this better than I can, but inventorship can't be, I was trained inventorship can't be transferred. If you were there on the inventive step, you're named. As far as ownership, that can obviously, that's a different story, but no, our practice absolutely, and I believe a best practice is start with just an introductory conversation that's vanilla, high level. What's the sellable aspects? What's the marketing materials? And then if we're interested, then let's talk expending some cost and getting legal fee, getting an NDA in place. And if for anybody on the phone or doesn't know what an NDA is, a non-disclosure agreement, it's a secrecy agreement.
Yeah, and Jessica, to address also the incident you raised with the investor. So people on the call may have heard reference to people talking about the U.S. having a first to file system, which is in distinction from the system we used to have, because it used to be a so-called first to invent system, and we don't need to talk about that necessarily. But to this point, in terms of it being a first to file system, that sounds like whoever takes an idea and runs to the patent office can file it. Okay, but indeed, and it's relevant in this situation, it's actually more nuanced than that, because what the United States has is a first inventor to file. So to Kyle's point about inventorship, you don't just get to run to the patent office and file a patent application on anything you want to. You can't steal someone else's idea and file a patent application on it. In order to file a patent application, you have to be the first inventor to file. So again, you can't take someone else's idea. You have to actually be an inventor. And indeed, for a situation like the one that Jessica described with the investor at the university, if indeed that person, I don't know if it was a man or a woman, filed a patent application that they did not invent, the true inventor has the ability to go into the patent office, and there's a proceeding in the patent office referred to as a derivation proceeding, which basically says, hey, that person, man or woman, did not invent it. They derived the invention from me, and then he or she went and filed the patent application. And if you can prove that, and there's evidence, and et cetera, you can effectively get the patent back. So it's important to understand it's not a first to invent system. I'm sorry, it's not a strictly first to file system. You still have to be the inventor. And so in the business, we refer to that as a first inventor to file system.
Thank you. That's really helpful. And the second part of that question was, can a patent owner stall the industry by filing a patent and not producing it? I would, answer that quickly. Yes, People do things like that, or blocking by publishing things so that no one else can patent it, because then it's public, right? So sometimes companies will just publish on something so that nobody can patent it. But this is in opposite to trademark, where you cannot just pick a trademark name and you have to use it within a certain amount of time and keep paying for it, or you do not get the trademark. So like someone, when they buy a website domain because they think it's going to be a hot topic and they're trying to hold it over someone's head, you cannot do that for a trademark. But for a patent, yeah, most of them don't become products. So this happens all the time, that there's a patent filed and you never ever see a product from it. And whether that's on purpose or because they fail, that is possible.
So
Just
it's
one.
interesting you talk about publishing. Sometimes when we want to maintain access to a market, but we don't necessarily want to invest completely in a patent, we will publish in the area to maintain access so that other people can't exclude us. Or if it's a weird approach to the technology and we don't think it's necessarily going to work, but if it does, it would be a problem. Like it would be, we need to maintain the ability to go there. We may end up publishing those types of things. And sometimes in foreign markets, we will make sure to publish so that we can maintain access if it's a tertiary market, but we still want to sell there, or not lose the ability to sell there. I interrupted Matthew, I think. I apologize.
Yeah, no problem. Thanks, Kyle. So just a couple caveats, Jessica, to your point about, or the question about being able to sort of hold the market away by patenting. One caveat: in many foreign countries, there are so-called working requirements. So if you have a patent in a foreign country, you're obligated at some point to prove that you're using the patent. And in some countries, including Brazil, for example, if you don't demonstrate that you are using the patent, it becomes subject to a compulsory license. Anyone can go to the Brazilian government and say, I want a license because they're not using it, and it will be granted. You'll get some compensation, but very little. The other comment about holding on to a patent, I'll just mention it's a very limited possibility, but for university-derived technology, that's typically licensed under the Bayh-Dole legislation. The government does maintain so-called march-in rights for federally sponsored research that is patented and owned by a university. In theory, the government can come in if you're not using your technology and say, we're going to exercise those march-in rights and license this to someone else so they can produce it. March-in rights are kind of a bugaboo because they exist and they've been used twice in 40 years or something like that. Although there certainly is talk about the potential of the government using march-in rights under Bayh-Dole, relative to vaccine and et cetera. But I just wanted to mention it for sake of completeness.
And a question: is filing a patent in the U.S. disclosure for the purposes of PCT? So you must file simultaneously or PCT first. You can file PCT and it covers the U.S. Or if you want, you can. Sometimes companies will file U.S. and PCT at the same time because they want to rush and get the U.S. one sooner. But maybe you guys can speak to that.
So
go
why
ahead.
don't you go, Joe?
Oh, sure. Well, so basically in the United States, you have up to one, actually, I think it's throughout the world, but particularly in the United States, you have up to 1 year after the filing of the US application to file your PCT application. So it's a 1 year runway, but to keep in mind that also applies, like if you file a provisional application, you have to get the PCT filed within 1 year of that provisional. So there is some runway to make that decision about filing the PCT or not.
Yeah, so it's a little confusing because now we've talked about two different 1 year periods.
Yeah.
The first one was your grace period after you've made a disclosure to file your US application. But there's also this 1 year period that Joe's referring to. And because you might hear it, I'll just mention this is referred to as priority. So there's actually a treaty in place, the Treaty of Paris from 1907. And basically it's under that treaty that the signatories of that treaty have agreed, if you file a patent application in a signatory country, as long as you file foreign applications within 1 year, the applications you file in those foreign countries will be considered to have been filed on your priority date or on the date that you filed it in the first country. And that filing date's important because that filing date determines what is and is not prior art to your patent application. So to answer the question in the chat, is filing a US application disclosure for the subject of your PCT? No, as long as you file that PCT within that 1 year period. Because if you file the PCT within that 1 year period, its filing date will actually not be the date you filed it. It'll be the date of that original US application that you based it on.
So we've hit a lot with patents and we're almost out of time here. I guess I wanted to cover those who are dealing with software a little bit with Joe, whatever we can fit in. You know, software is a really tricky item with patenting. It would be often definitely the code is a copyrighted work. You know, what are the key points you might share, Joe, when thinking about software, hiring folks to write your software, anything really?
Yeah, so I'd say as the starting point, a fundamental thing we look for is confirming the ownership of the software. So as a startup company, as an early stage company, making sure that number one, with the members of the startup, there's a written agreement that all of the code that's going to be written is the property of the startup, that you're going to actually assign ownership in the copyright and any other rights in the code to the startup. And then stepping out as you add employees, very important to make sure that the employees sign an intellectual property assignment agreement. And then if you work with non-employees, we'll call consultants or contractors to help with the code, very important that they're also signing agreements assigning the ownership over to you. So that's where huge messes are created with software when you get into ownership fights. So that's really the starting point. And certainly thinking about filing for patent protection on the software features, that's topic for a whole nother couple hours because it's complicated, but at least something you want to think about. But then also with your software is once you've got a product you're getting ready to commercialize, to register your copyright on that software. So you automatically have copyright protection as soon as you write the code, but registration in the US gives you enhanced protections over the code. Most important of those are what are called statutory damages. So if you don't have copyright registration, if somebody copies your code, you have to demonstrate the actual economic harm you've suffered. If you're an early stage company without sales, a lot of times that's not a very big number. But with statutory damages in play from registration, you can fire off a cease and desist letter threatening up to $250,000 per act of infringement. So that really, that will get people's attention a whole lot faster.
Great. We have 1 minute left and I think we could go on forever. We could have a whole other panel on software. So if people are interested in that, let me know. I don't know, anything final? I know, Matthew, you had mentioned, beware that you wanted to mention of putting too much in your original patent filing, like that was a warning you wanted to mention.
Yeah, I mean, I do think it's important on a couple of levels. Disclosure is important. Kyle's right, it's a legal document, but it's also a technical document. And your ability to get property rights, to write those claims at the end of the patent are governed by what you disclose. You can only get patents or claims rather on things that are supported by your technical disclosure. Recognize the more disclosure you have, the things that you disclose in your patent, but that don't end up being claimed, those effectively are dedicated to the public because you've disclosed them and they're not patented. So that's something to be sensitive to. I particularly want to raise the issue though relative to provisional applications. I think that there's a perception that's somewhat accurate that a provisional is sort of a quick and dirty application, or you can do it in a hurry, or you can just sort of take everything on your desk and file it as a provisional application and figure stuff out afterwards. To some degree, that's true. Provisional applications, if you just file the provisional application and then don't ever do anything with it, it dies, it never sees the light of day, it's not a public document. It's not even considered publication for patenting purposes. However, if you do like say, take your whole lab notebook and say, oh, I'm just going to file this as a provisional and we'll figure it out later. And if you do, and if you end up filing a patent on that provisional application, in that context, even though the provisional dies, it's still publicly accessible because you're basing a patent application on it, and someone has to be able to go and prove, and you have to be able to ultimately prove that what's in your patent application really is entitled to the filing date of the provisional. So that provisional can be public domain. So the concern again is if you took your entire lab notebook, all your work for the last 10 years and stuck it in the patent office to get a patent on just one small aspect of it, in theory, you've just opened up all of your research for anyone to ever be able to go, for anyone to be able to go in and look at it all. They may not be able to patent it, but so it's just something to be aware of. Disclosure is really important to getting good claims in your patents, but there's also risk, and particularly if you just throw everything in the patent office in a provisional.
Thank you. I guess we've hit our time, and I really appreciate all of your insights. Obviously, you can always, Joe is a patent attorney, so if you ever want to contact his firm and, you know, need any help, great. And otherwise, you know, follow up with me if you have more ideas for panels. I see there's some interest in software and so on, so we'll definitely take a poll of what to talk about next. And thank you all again, and have a good rest of your day.
Thank you, Joe.
Thank you.
Thank you, Kyle.
Most welcome. Thank you.
Bye.